The sources of U.S. privacy law are identified here on the screen for you. We've talked a little about the U.S. Constitution, and we're going to talk more about statutory law that comes up mostly in a business context. We'll identify that in Mod 3. For purposes of the video here and in Mod 2, where we're talking about the relationship of the individual and society and data analytics and artificial intelligence, we're going to focus on the common law source of privacy law in the U.S., which is tort law. Tort law is law that protects us from emotional harm, financial harm, and physical harm. It is state law. It's common law, meaning we find the rules of law in the cases that we read about what these torts are. So these have all been created. These torts were created by our court system in the United States. There are many scholars that are looking at tort law as one aspect of privacy law that might be very successfully used to protect individuals from the use and misuse of their data. The answer to this question is still outstanding. We don't know the answer, but we're opining at this point that this may be an area that we can find some protections for individuals who feel that their private information has been used and misused in a way that causes them emotional, physical, or financial harm. There are 4 intentional torts in privacy: intrusion into seclusion, appropriation of name or likeness, public disclosure of private facts, and false light. Each one of these addresses specific different aspects of privacy, but what they have in common is that in each case we have to be able to identify that the individual who's alleging harm had a reasonable expectation of privacy. That's not always easy in this new technology, but is definitely mandatory that we are able to show that. So intrusion into seclusion, the first one, basically is what it sounds like. You are intruding, someone has intruded into the seclusion of somebody else. Classic case, peephole in a women's dressing room, and somebody is peering in unwantedly into this private area of the dressing room space. In the context of new technologies, some are arguing that the Internet of Things, in particular, this interconnected network of sensor data from consumer devices like Fitbits and smartphones and smart appliances and so forth, that the misuse of that information might result in an intrusion into seclusion. It's a tough argument because you have to show that there has been an unconsented to use of it, and you also have to show that it is highly offensive to a reasonable person. But we're going to revisit this in Mod 3 when we look at some of the statutory protections as well in some of the cases related to the Internet of Things, particularly those that have been addressed by the FTC. The second one, appropriation of name or likeness, or sometimes called misappropriation of name or likeness, protects our identity. So if somebody uses an aspect of our name, likeness, picture, identity to their commercial advantage without our permission, that is an appropriation, and that's a privacy violation because we have an expectation of privacy in our identity. Classic case is somebody taking a picture of a famous person and putting it on t-shirts that they then sell to their commercial advantage. In the context of new technologies, there's a question of whether or not data brokers, other entities, organizations in this new space who are using parts of our identity, if that is an appropriation. If it has been unconsented to, it could be, but it's not clear because the commercial advantage piece has to be established. And again, we have to also show that there's a highly offensive misuse. The third one, public disclosure of private facts, occurs when somebody discloses private facts about another, and those private facts are highly personal. The disclosure is public, and it is highly offensive to a reasonable person. So if somebody discloses to a community that their neighbor has a highly infectious disease without their consent, that might be considered the public disclosure of a private, albeit true fact. Because it's offensive, it's a violation of that person's privacy and private life. In the new technology space, in data analytics, artificial intelligence, there can be aspects of this that happen as well, where things about us that are true but private come out. Again, questionable whether or not in this age of sharing forward so much information about ourselves, we can argue that we're offended because we share so much. But at least some scholars are saying there's a possibility here that this kind of disclosure could be actionable in this new technology arena. The problem here is that the publicity piece is not clear. Publicity isn't necessarily equated to the trading of our information. So when data brokers are trading forward our information, is that publicity? Is it highly offensive? It's not entirely answerable at this point. The last one, false light. This occurs when a person is put in a false light, either it has to be publicly, but it has to essentially just a misalignment of who we are. So taking a picture of somebody and putting them under a headline in a newspaper that says something that is false would portray that person falsely. This one is really, really new in data analytics and artificial intelligence. We haven't seen a lot of it, but again, it's possible that you could be falsely portrayed. Certainly have seen cases where our data has resulted in false information and false conclusions about us, that we are falsely portrayed, and that causes an emotional, physical, or financial harm to us. Still, we have yet to see any of these cases. No data traders have been sued under U.S. tort law, to my knowledge. This is all speculation, but to the degree that we can stretch these torts a little bit more than we can stretch statutory law, there's argument that there is protection here for individuals.